Our most popular videos are always about the concepts of title, deed, what is a deed, really anything related to that. And I don't understand why. Even though I am Tiffany Weber, I'm a real estate attorney and I do this for a living, and I figured people must not be getting their questions answered. So I compiled a list of the 17 title and deed questions every homeowner asks, but no one explains. And we are going to go through those rapid fire right now. First, what's the difference between a title and a deed? Title is a theory of ownership. It is the concept of ownership, and a deed is the piece of paper that proves you have that ownership. Who actually owns my home, me or the bank? North Carolina is a title theory state, so your name is on the deed. You are the grantee of the deed. You are the owner of the property. But if you have a loan on your home, then the bank basically is a holder of title to that property. They have a security interest to the property, and you can't just freely sell the property and never pay the bank back. So the bank does have a security interest in the property, but you are the listed grantee on the deed. Next, how do I get a copy of my deed? Well, first, you're probably going to get the original in the mail. Usually the closing attorney facilitates getting the original back to you, though you don't need the original. It's just a keepsake once it's actually recorded on file with the county. But if for some reason you have misplaced your original or lost your copy, you can go to your county's Register of Deeds website and get a copy online day or night. At least in North Carolina, you can. Do I need to record my deed, or is it automatic? A deed does not always have to be recorded to be effective. That is an extremely rare circumstance. So for most people, I'd say 98% of people who are doing any sort of transaction, yes, the deed needs to be recorded, but that is usually handled by your closing attorney. If you had someone just hand you a deed and that's signed and notarized and it hasn't been recorded, you need to record it. What if my name is misspelled on the deed? In some cases, you may not need to do anything until you sell, in which case there's an easy way to fix that whenever you sell by having an also known as or a formerly known as on the deed. But in some cases, you may need to have a corrective deed prepared and recorded. How do I correct errors on my deed? Depending on the type of error, you handle it differently. If it's a minor clerical error, then there's something that's basically a clerical affidavit for minor typographical things that can be recorded, but for other things, you would need a corrective deed. And by other things, I mean legal description errors, the wrong person named, etc. Can I add or remove someone's name from the deed? To remove, not without their permission. To add, yes, that is also by recording a deed to make sure those changes get properly logged with the Register of Deeds. How do I check if there are liens on my property? You have to check a couple different places. So one would be the Register of Deeds. The other place would be wherever you check for judgments, wherever you live. So in North Carolina, we have an eCourts portal where you check for judgments. In North Carolina, we also have a uniform lien site for builders to go and file liens. You can check the Uniform Commercial Code filings with your Secretary of State, and then also Pacer for any bankruptcy issues. There's at least 5 different places you could check. You need to know where all of those are, and depending on your state, there might be more. What happens if someone files a lien after I buy? Well, if that money is owed by you, then they could file suit to collect the money. If it's on a prior owner, then hopefully you got title insurance and that the seller signed an affidavit that they would defend you against any claims of lien that were really for something they did wrong. But if a lien is filed after you bought, one way or another, it's going to have to be dealt with. How it is dealt with depends on whether it is something for your conduct or alleged against you or for a previous owner. Can an old lien affect my ability to sell? Yes, a properly perfected old lien can affect your ability to sell. So it would either need to be released or paid off if it is valid and properly perfected. What does title insurance cover? This is a loaded question because it depends on the type of policy that you have. But for an owner's policy, a standard policy, the main thing you're looking at is coverage for defects in the chain of title past. If there was a fraudulent deed in the past, if there was some error in the past, then it would be covered so that it doesn't harm you. If you get an enhanced policy, then there can be some forward-looking coverage. So in the event that someone forges a deed in your name to someone else, if you have an enhanced policy of title insurance for a homeowner, then they could cover for that too. But it all depends on what type of policy you have. Do I need title insurance again if I refinance? Maybe, maybe not. Title insurance is just like any other insurance. It's for a stated amount. So if you buy a piece of vacant land and then you build on the property and you refinance, the value of the property is quite different. So you may may want an endorsement to the policy, but you could reach out to your title insurance company to see what needs to be done for that. What is a cloud on title and how do I fix it? How you fix it depends on the type of cloud on title. It would be impossible in a rapid fire segment to address all the different ways to fix a cloud on title, but a cloud on title could be anything from an error in the legal description, undisclosed easement, a new restriction placed on property that was not agreed to by a buyer. It could be a deed of trust. It could be a judgment. All of those things are basically anything that keeps the title from being perfectly clean and clear as a cloud on title. How do easements or restrictions show up on my deed? They probably don't show up on your deed. They probably are in the public record in a separate instrument. They can be referenced in your deed. So some restrictions that are like deed restrictions would be literally spelled out within your deed, and occasionally an easement would be referenced, but those things do not have to be referenced within your deed to be binding upon the property. They just have to be located within the public records within the relevant time period and not be expired. How do I transfer my property to a family member? So this is also a loaded question. It depends on whether you have any other tax considerations. So if you just want to get rid of your property during your lifetime to another family member, you can sell it to your family member or give it to your family member, possibly with tax consequences, and deed the property to the family member. You could also transfer property to a family member by a trust or a will, so that would happen after your passing, and that family member could possibly get a stepped up basis when they take the property. All of that you need to talk to your CPA about, so you structure it the best way to avoid unintended tax consequences. What happens to the deed when I pass away? Nothing happens to the deed. Things might happen to your title, but nothing happens to the deed. Nothing changes about the deed itself. When you pass away, the title to the property will flow to whoever your beneficiaries are if you have a will, or your heirs if you passed away intestate. So that's going to be controlled by your estate plan. So the title would pass, and then as part of wrapping up your estate, then a deed could be executed to update the names of the new owners, but without any sort of action by whoever's administering your estate, nothing happens to the deed. Can someone else claim ownership of my home? Unfortunately, anyone can claim anything. That doesn't mean they're correct about it. So I guess technically someone could claim ownership of your home. That doesn't mean that they have the right to your home. Just because someone states something doesn't mean that it is so. If you've got a proper chain of title showing that you own the property, then there's usually not someone that can just come out of the woodwork and say, actually, this is my property. An exception would be as if there was some unknown heir as part of an estate administration and they didn't get included or weren't properly notified of some proceeding. But that is so rare that that would happen. It would be more likely that there's someone who's just trying to be opportunistic and or get something for nothing, and they would need to prove that they had superior ownership to you. So let me know what you thought of this rapid fire style. Hopefully it was helpful. If you like it, we'll keep doing it. In fact, if you have any other questions about real estate, feel free to throw them in the comments, and maybe they'll be in our next rapid fire video.